गर फिरदौस बर्रुए ज़मी अस्त, हमी अस्तो हमी अस्तो हमी अस्त. If there's a heaven on earth, it's here, it's here, it's here. I'm sure the moment I said these lines, all of you are thinking about Kashmir and its beauty. But we also know that the erstwhile state of Jammu and Kashmir has often also been associated with a lot of disquiet. Almost 4 years ago, India's relationship with Jammu and Kashmir was redefined. What happened was around 11 a.m. on 5th August, Union Home Minister Amit Shah declared that the government had decided to do away with the special status of the erstwhile state. How this was done was 2 presidential orders were issued and Articles 370 and 35A were essentially scrapped. A few days later, a law was also passed, Jammu and Kashmir Reorganisation Act, and through this law, the state was bifurcated into 2 union territories, just Union Territory of Jammu and Kashmir and Union Territory of Ladakh. And all of these, the legal issues around this, Article 370, Article 35A, and this law is what we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra, Sinha, and we have with us Supreme Court lawyer Pallavi Pratap. Thank you so much for joining us, Pallavi.
Thank you for having me here.
Thank you so much for joining us, Pallavi. So our first question is, we want to talk about the history or the background of Article 370 as to how it found a place in the Indian Constitution after partition or at the time of framing of the Constitution.
So essentially, if we look at it, the history in a manner of speaking goes back to about 1912 in all, where primarily one noticed that there was this whole movement which was called as Kashmir for Kashmiris. This was brought about to make sure that people who were outside of Kashmir were not really becoming part of Kashmir essentially by purchasing land. The reason was that at that time, obviously the weather of Kashmir is so beautiful and such a nice place to live in. A lot of Englishmen wanted to settle down there. So in garb of that Kashmir for Kashmiri, they primarily wanted to ensure that people from outside were, one, not able to buy land, and two, they were not given any jobs which were government jobs as such. So they tried to make sure that only people from Kashmir were, one, able to buy land and of course get any kind of employment, government employment. That movement was very successful, and after that we see around 1947 when the partition took place. So Junagadh and Kashmir were two of the most, I think, essential areas that we looked at, where Junagadh we saw that even though the population was Hindu dominated, the ruler was Muslim. So therefore a referendum of sorts was conducted, and then the army went and ceded it. However, as far as Kashmir was concerned, the Maharaja was ruling a Muslim dominated area. So therefore his idea was that he was not still sure whether he wanted to join the Indian territory, or he wanted to join the Pakistanis, or he wanted to be an independent country in himself. So he was sitting on it for some time, and suddenly there were these tribals who came and they attacked in Srinagar and adjoining areas. So at that point in time, he was not able to defend his territory, and that's when he called up the the central command here in Delhi to ask them to send forces so that defense of Kashmir could take place. And it is at that point in time when it was discussed with them that why wouldn't you then join the state of India, because we will be providing you that defense. You do not have armed forces of your own, and we will be able to provide you that external affairs, communication, etc. There were 3 major areas that they had decided that government of India would take care of. So he, I think he took about 1 day to decide that, and then he said that no, this sounds like a fabulous idea, and I will go ahead with it. So then the Maharaja actually asked the central government, the Union government of India, to provide the Indian Army's support to take care of the tribals. Now that internal war kept going on for 2-3 years. However, it took Maharaja some 1 day to decide whether or not he will sign that agreement. He was at that point in time in Srinagar. He traveled to Jammu. Took him about a day in those days to travel, and then he came and he signed that agreement where he decided that he will be part of India. And that's how, at that point in time, a constituent assembly was formed of Jammu and Kashmir, where Article 370 was it was called as Article 306 at that point in time. And there, the entire, the skeleton in that sense was drafted. And interestingly, and this is where I want to add it, because later when we discuss about how 370 gets abrogated, it was written that it is only at the behest of the president that the 370 can be scrapped off. However, it was also mentioned that it will be on the aid and advice of the Constituent Assembly. So I think this was the tricky situation which was there, and that's primarily how it started off. Now, when the Constituent Assembly came up with 370, we see that, in my opinion, if you look at the history of 370, we see that the dilution actually began from 1950 onwards. Okay. You would see that where in 1950 it was said that the Maharaja will be there, that got diluted with Sadre Riyasat, which is where the state legislative assembly was then supposed to recommend for a Sadre Riyasat, which was equivalent of a chief minister. Then further, after few years, we see that even though they used to have their prime minister till 1965, that got diluted and again a chief minister comes in. And then there were essentially other rights, but slowly, and I think around 1955, when they adopted the Indian Constitution, fundamental rights became a part of it, because then they were also considered as Indian residents. They got the opportunity to hold the dual passports, so to say, and they also had other rights which we were providing to all the other citizens. For instance, if we look at the
before you move ahead with those rights, I just want to ask you one question. Yeah. It gave a very unique status to the erstwhile state as well as to the people of J&K. Can you just talk about those privileges first, and then we can probably go ahead and talk about the rights that were extended to the residents of J&K as the dilution continued?
Privileges through 370.
Through 370, yeah.
As well as through 35A,
yeah.
If you could talk about.
I think privileges were definitely there, but more so, I think there were handicaps which I would like to talk about pertaining to women. One, of course...
do you see those privileges as handicaps pertaining to women?
Because I think they were definitely handicaps. I mean, specifically, if a woman was who was marrying outside of Kashmir, was losing her PR status, which is the permanent resident status that she had. So essentially, they would issue a certificate for 10 years, which was a permanent resident certificate.
This was issued to every citizen?
To every citizen, male, female, alike. Now, if a female gets married, then she will have to get it reissued. And at that point in time, it will be checked whether she's marrying someone from Kashmir or is she marrying someone outside of Kashmir. Okay. The moment
this
she
would
marries,
be Jammu and Kashmir?
Kashmir, yes.
Okay.
The moment she marries someone outside of that state, she loses her permanent residency, which essentially means that she cannot retain any property rights or purchase any immovable asset, which is basically land in the state of Kashmir. That also meant that if there was a government job, there was a very famous case of Sushila Sahani, which took place. And then there was a series of other cases where they said that even though that lady belonged to Kashmir, and she was an assistant professor in one of the universities over there, she had to lose her job only because she got married to someone outside of Kashmir. This was completely uncalled for, and you will be surprised to know that this, there was a full bench of High Court which sat in the year 2002 to decide that this is completely against the rights of women and that something like this is illegal. Okay. And how many years are we talking about? Essentially about 52 years where women were not able to assert their rights. Similarly, there was also inheritance rights of women. Unlike in how we have Hindu Marriage Act, where that also got diluted after a long period of time, or for instance, daughters who were there, Hindu daughters who found it difficult to inherit property, In Muslim law, the girl actually gets it by virtue of being a daughter. Now, the moment that daughter actually gets married to someone outside of Kashmir, she loses that right. So that also, again, in 2002, the full bench decided that no, you cannot curtail the right of the daughter. So I see that, as we've always seen, that women in most laws have been,
there has been some sort of discrimination.
Yeah. This was essentially a very big discrimination for someone to not be able to marry someone of their own choice. I think that was a big fight that many of them had to fight.
So, did Article 370 in any way bar implementation of other laws on J&K?
Of course it did, because every single law in the country, except for a few of them, we see that there was always that term which was used, that except for the state of Jammu and Kashmir. They had their own penal code, Ranbir Penal Code. They had a lot of other laws which was applicable on everybody else in India, but not really applicable on them, except for the income tax and some few excise acts here and there, and that too actually got accepted very later on in the history or the timeline that we see. So I think those laws were definitely causing trouble in terms of implementation. If I, as a citizen of India, am allowed to buy or marry or do XYZ over here in rest of the country, I am not allowed to do that as far as Jammu and Kashmir is concerned. And we've always considered, as a matter of fact, Article 1 itself says that Jammu and Kashmir is an integral part of India. If it says so, then why is it that it was not really brought into that coverage? I think dilution or abrogation, in that sense, we could see that it was a step-by-step process which was going on by little bit here, little bit there. But then final, like you said, in 2019, when it was finally done away with, I think whatever I've spoken to my Kashmiri friends, they've always said that that was something that was already, in a sense, practiced. So it was not so much, except for the skeletons maybe of 370 which was surviving.
So now, since we're talking about when it was done away with in 2019, could you also tell our viewers how that was done away with, and the Constituent Assembly thing also, that how did they get past that hurdle?
I think how they did was that Constituent Assembly was, of course, done away with. So there was not so much of presence of Constituent Assembly which was remaining. So what
at that time there was no government; it was under the
that was at the time of 2018.
Yeah.
The interesting thing that they did was that they brought amendment in the General Clauses Act in order to ensure that because the Constituent Assembly was not there, so you had to use certain other terms like state and the like to ensure that that could be read in order to get us the required authority to do away with the 370 abrogation. So, of course, where you have lawyers, they will apply their legal mind and come up with interesting, footnotes to get over the legal hurdles. And that's how at least the terminology part was done away with. But what they did was that when the elections took place, there was nobody who had a clear majority. Now the provision says that you can't have more than 6 months of precedent rule. They tried to have that precedent rule. I think twice they had tried to establish a government, but that could not be done. Then twice they had the precedent rule. I think that turned out to be a very fertile ground for them to realize that this is the perfect stage to move with the abrogation of 370 and move on, move forward. Because it only required the president to say it. It was not that you had to, go through the entire constitutional amendment and everything. It was not required at all. And it was very clear, like I said in the initial part, that 370 itself came with how it could be abrogated. So essentially, with the precedent rule written, with the president's consent written in it, it was easy for them to bring about. However, there have been, in the writs which are pending, there are specific grounds where they've taken, where they say that when you were having your Jammu and Kashmir Reorganisation Act, which came in 2019, the Rajya Sabha did not really have.
Yeah, that's what, in fact, we were going to come to that now, because of course you've spoken about the J&K Reorganization Act and the circumstances under which it was, Article 370 was abrogated, and then this act was brought into force. Of course, this act and the abrogation of Article 370 took away that so-called special status or privilege given to the erstwhile J&K. I mean, it broke the state into two UTs. But this, I mean, still there have been so many challenges to it, there was so much of criticism to it. And now we all know that for the past 4 years, there are petitions pending in the Supreme Court. So there are multiple, of course, there are many of them, but if you could just focus on very few significant ones to explain to our viewers what exactly is the real challenge to this act.
So, 11th July onwards, they will start hearing the writ petitions which are pending. And primarily, how I see it is that they can broadly be covered under three areas. One is, of course, the challenge that lies to Jammu and Kashmir Reorganization Act. Then there is the challenge, the essential challenge. The first challenge that came was to the President's rule. That's how you will see that the first initial petitions are all challenging the President's rule. Then there were challenges with respect to the internet shutdown, which we've all seen how Anuradha was seeing how it went off. Really interesting observations that came out of it. And then, of course, the challenge was to the smaller aspects of it, the different orders that came, or there were these 551 GS, which was there, all these different gazette notifications which were there. Those are the challenges that they've done. Now, there are some, in all, I think 23 petitions which are lying just now. And it will be interesting, I mean, to see what the arguments are in it. I think my personal understanding is that the precedent rule part of the writ petition, if you see, has become essentially infructuous, except for maybe the question of law with respect to it. I think that part we would not find so much meat in it. But I think the Reorganization Act, the challenge to the Reorganization Act is something that we will have a lot of debate and argument on.
Could you tell our viewers a bit about the powers, how, I mean, essentially, how is a state or a UT, how is the character change? Where does it draw the power from, or the constitutional provisions where that power comes from?
So now if there is a state, no, Apoorva, we will see that there will be elections which are conducted, right? But in the past 4-5 years, around that time, we've not seen even a single election being conducted as far as Jammu and Kashmir is concerned. As a matter of fact, I think there are quite a few news articles that keep coming in where they discuss that, even if it is a union territory, there should be some kind of democracy that should survive. So I think that is the biggest challenge which is there. Then the challenge lies to the fact that when you are a state, you have the right to, legislate on the state subjects, right? Or if the union government is legislating on anything which lies in the union list or in the concurrent list, they will always have a say to it, to if they want to completely adopt it or not. But those parts are then gone, because then you have the union government which is legislating on most of the areas. So I think these two are primary factors that I see. The fact that there is no democracy in that sense that is there with respect to right to vote. There is no election. If there is no election, then you are not choosing anyone, be it a corporator, your Panchayati Raj, which is an essential component, I think, of the entire country. So all of that is then diluted. So you don't have that local self-government. And therefore, I think Kashmir is one place where we see a lot of problems with medical, facilities. They don't have good hospitals. People over there find it very difficult, especially the ones who are in the hinterlands, Ladakh areas and all, find it very difficult to find good hospitals. And I think these are the reasons why you would not be able to find, if there is no voting which is happening, if there is no self-government, how is it that they will be able to voice out their concerns?
Those are the changes in the governance that have been brought about in the state. pursuant to the J&K Reorganization Act,
Yes.
right? So we touched upon the petitions that are pending in the Supreme Court, and as we know that next week the Supreme Court will start hearing on it. But the central government has given its submissions to the court defending it. Can you just shed some light on that as well, in the sense what exactly is the stand of the central government? What are the arguments the central government has taken to defend or justify the J&K Reorganization Act? Of course, detailed arguments are going to follow in the court, but just on the basis of whatever they have submitted in written so far.
I think they've made some very interesting arguments. And one of the arguments that really catches my thought is that, like I said about the medical infrastructure, they say that there are no private universities in Kashmir. Okay. There are not many private hospitals in Kashmir. You don't have private investments in Kashmir, because even though they've diluted a lot of the provisions, the industries are not, or rather the industrialists are not looking at it as an investment hub. And for any state to develop, economy for that state is the most important part. I think the only thing that they rely upon largely is the tourism, and that too, because of certain activities that take place, will not always be 365 days. It is not the same. So therefore, I think one of the biggest argument that the central government has is, of course, with respect to private investment, but also I think the fact that the government in their poll manifesto had said that they will be scrapping away with 370. So I think one of the reasons, if not argued in such a manner, but garbed in that way, has been that 370 abrogation was important. But like we discussed, most of it was anyway diluted. So it was only just a little part here, there, which was left. And now I think if you look at it, the tourism since the lockdown has actually increased everywhere. And same has happened with Jammu and Kashmir also. So I think the economy now has finally started to pick up. The infrastructure in terms of road-wise has increased tremendously. One of the arguments that the government has made is also that whereas the government is spending about 25,000 rupees per person per year in the rest of the country, in 2011-12 they were investing some 3,000 rupees on every Kashmiri. Now it has risen up to 8,600, which is what
after the abrogation. This is what the central government is saying.
So that therefore they are saying that there is an increase now in terms of what the government is investing as far as the citizens are concerned.
So is it the central government's stand that Article 370 was like a major block to development in that area?
Yes, I think that is one of the biggest stand that they've taken. And they have the past 2-3 years also to show that development has essentially taken place with the roads. I mean, there are 6-lane roads, 4-lane roads that they've made, which I think they're all cemented roads, which is how they've been making it right from Kashmir to Kanyakumari. So I think all of that has been written in their affidavit, and they have been focusing primarily on the fact that this is most important, because if you want to counter terrorism, you have to make sure that economy is actually working over there. The youth has employment opportunities, that there is money with them so that they don't fall prey to militancy or terrorism. So I think that's their essential argument.
So Pallavi, you said that there were challenges to the presidential order, but subsequent to the J&K Reorganization Act coming into force, those challenges have virtually become infructuous. So are you trying to say that whatever decision is given by the Supreme Court, as far as the presidential order is concerned, that will now just be like academic exercise?
It will be, in my sense. I might be wrong also, but I understand that because those presidential rules actually took place only in 2018 twice, right? Yeah. So if you're challenging that now in 2023, when it has already become a union territory, unless and until that entire act is done away with, that I feel would not be the main crux of argument.
Okay.
That's my understanding.
Just
of it.
imposition of presidential
Presidential
rule won't be the.
Okay.
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 That's my understanding.
With this, we've reached the end of this episode. As we started the episode, we told you how almost 4 years ago, India's relationship with the erstwhile state of Jammu and Kashmir was redefined. How that was done, how that relationship was redefined is set to come up before the Supreme Court in the next few days, and we're going to keep an eye out for the arguments that take place in the Supreme Court, and we'll keep updating you. As for this episode, thank you so much for joining us. Hope you enjoyed the episode. Do let us know in the comment section like you always do, and keep following us on social media.